Welcome back, everyone, to the latest episode of Decoding with Finsec. Decoding with Finsec is a podcast through which we bring to you the latest developments in the securities market and in securities laws. I am Navneeta Shankar and I have Anil with me today. Today, we'll be discussing the latest amendments and recent changes that have been brought to the insider trading regulations by SEBI. So the three main changes that we'll be discussing today is expansion of the meanings of connected persons and unpublished price sensitive information, or UPSI, and the recent SEBI circular on freezing of PANs of designated persons and immediate relatives to ensure that they don't inadvertently violate trading closure of trading window norms. So the starting with the expansion of definition of connected persons, the concept of connected persons becomes important from the point of view of determining who will be an insider, because the PIT regulations clarify that every connected person shall be an insider and shall be barred from communicating or trading based on UPSI. So this meaning was previously categorized into two parts. First would include the persons who have been connected with a company for the last 6 months by virtue of being an employee of the company or through a contractual or fiduciary relationship. And the second was deemed connected persons, who would qualify as connected persons by virtue of being an immediate relative of the connected person. So now the change that has been brought is that this term immediate relative has been replaced with the term relative, which is a broader set of people related to a connected person, including the spouse of a child of the spouse of the child of the connected person, or the spouse of the sibling of the connected person. So, Anil, what do you think is the reason for this expansion, and what do you think would be the impact of this expansion?
I think from the point of view of understanding what is connected person and deemed to be connected person. Now, deemed to be connected person is where the change of law has occurred. Connected person is any person who is in contact with the company for past 6 months.
Correct.
So suppose I'm a lawyer, I'm an auditor, I'm not an employee, I work on a contractual basis or from some work that I've been doing with the company, or I'm a vendor. So I'm in contact with the company. So law presumes that I have some inside information if I'm in connection with the company for past 6 months. So I'm a lawyer. Okay, fine. But deemed to be connected person is people who are connected to me, people who have been in connection with the company for past 6 months. So let's say if I am connected to the company because of the relationship with the company I have had for past 6 months, my wife, my child, all will be, my mother, my father, my brother, my sister, all will be seen as deemed to be connected. So what is the impact of that? So assuming I am advising a listed company client and my brother trades on the listed company stock, the law will presume that I have passed on the information, or law at least will presume that my brother has received that information and is in possession of UPSI, and they do not have to, SEBI does not have to prove the communication of UPSI to such people like my brothers who are connected to a person who is already connected to a company. So that is the impact of the deemed to be connected. Here, it only as a very, very unique country wherein you don't have, SEBI does not want to prove that there is a communication of UPSI. They keep on expanding of the people wherein SEBI does not have to go and prove that that person received the UPSI. So the whole logic of SEBI, why SEBI has done this, is to ensure that if I find any relative also of a connected person, then I will presume that that is insider trading, and you prove, because it's a rebuttable presumption and under the deemed connected person, so that my brother will have to prove, no, 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 my brother, that is me, has not passed on to the information to me, I traded on my own. So that is what the law now changes. Now, what law changed has, earlier it was immediate relative. So what is the immediate relative? If you see the definition, it's a defined term. It says that immediate relative is a person who not only is father, son, whatever the relationship is there, but also takes a person who is not independently taking the financial decision, basically consulting me to take the financial trading decision, and also not financially dependent on his own. So basically, if my brother was financially dependent on me or was consulting me for my trading decision, then only he would have been covered in the earlier definition. Now that has been removed. Now it's only relative. So not only this scope has been increased. So basically, my wife's brother's spouse is also now covered.
Correct.
My children's spouses are also covered. So more and more people are getting covered, and the exemption which was there earlier on the financial dependence on who is taking the trading decision has been taken away. So when you ask me as to what is the impact of it and what are the reason behind it, the reason is that SEBI does not want to do the hard work of finding the communication of UPSI. That's why if you remember they came up with a pushta regulation saying that if it's a suspicious trade, I will find you guilty. I don't have to prove that there is suspicion why this trade was done and you have done insider trading or not. So I think from an impact perspective, what they are saying is that if any of people who are related to an person who's connected to a listed company, it will be presumed to be insider trading, and you have to come and prove why it is not. So the problem is in this case is that like people like us fiduciaries that we who advise listed companies regularly, you know, don't have to only tell your parents and all. And even if let's say father and mother, they earlier there was a caveat that if you're taking independent financial decision, and then I'll not be hauled up for insider trading.
Yes.
And that has been taken away. B, new set of people have been asked. So my wife's sister's husband is also qualified. If I got an information about my listed company I'm advising on, my wife's sister's brother, my wife's sister's husband, if he also trades, then also I'm covered. Then he is in trouble, I'm also in trouble.
Correct.
So and this kind of is expanding the scope of it, and that also the deeming provision is quite dangerous. It's very difficult for somebody to prove it otherwise, that you prove to me that the information was not shared. How do I prove that the information was not shared? As in, if I've had a phone call between him and I've had phone call past 7 8 years 10 years ever since I've been married, and they will pick up the 3 phone calls between that period and say, see, you spoke to them, you must have passed on the information. So it is very burdensome on somebody to disprove that there was no communication of UPSI. So people like my wife's sister's husband, I get trouble if they trade. And how do I stop them from trading? And I trade, I advise on listed companies every day. So today is X company, tomorrow is Y company. If I keep telling don't trade in X and don't trade in Y, he will definitely trade only those two stocks. That also is passing on the information. Now that's why I think law in India anyways is very tough to follow when you make presumptive provisions. Presumption, you're presumed guilty, now you prove why you're not guilty. I think from that point of view it has a lot of impact. It is just one small little amendment in a small little regulation, and people do not understand why SEBI is and how it's doing it. But I think from a point of view of impact, it's quite onerous. And also you should, all these listed companies, people who are advising, working on the listed company matters, should be educated about it. That see, you'll get into trouble even though you do not know that somebody has traded in the stock, and which I've seen in the past. So that's the impact overall.
I think two more changes that have been brought to the meaning of deemed connected person is that any firm or any partner or any employee of a firm in which a person is a connected person would also be a deemed connected person. And any person, say I am a connected person and I'm sharing my household with any individual, that person also becomes a deemed connected person. So SEBI seems to be widening the scope in all directions, so that, as you said, to reduce its SEBI's own work of identifying people and just putting the onus on them to disprove that they're connected persons and they weren't insiders in a certain scenario.
I think their logic is, as long as I can make a logical flow to it, I don't care, because it's also for their defense. Not that I'm defending them, but it's very difficult to prove communication of UPSI. So they want to bridge that gap. That don't ask me to prove communication. It's a task. If some people are having, only thing they have access to is call data records. They don't have access to, they can't tap phones, etc. Only in tapping phone, or you are mirroring somebody's phone and all, and cloning that phone and getting all these messages, or have have concerted effort of tapping the phone and finding out, then only you can find direct communication. Otherwise, very difficult to find direct communication. So SEBI is using this route to find every other person who could be possibly be connected. Now, if you're, let's say, employees firm, so if I am working on a matter, we are a small firm, 15 20 people, but if you go to a larger firm, which have 500 people working in a firm, so if one team member is working on one matter, all, and that firm becomes part of the designated person, or part of the people who are connected persons, then what happens is that entire uh, firm becomes, and all the members of the firm become members. So it was a very painful process for people to disprove the fact that there has been no insider trading done. So SEBI's objective is to basically make it easier for them to prosecute. It does not increase compliance of listed company, because you don't have to maintain a list of database of connected persons by a listed company. Listed company only has to maintain a list of designated persons.
Correct.
And there the definition of immediate relative still stand.
Yeah.
So there's a difference between designated persons and connected persons. Designated persons are persons who are employees of the listed company, who are covered under a code of conduct, who are people level 1 or level or 2 level below the directorship, who are the key people handling and supposed to have the UPSI. There you have kept immediate relative. But in connected persons, you have changed it to relative without any caveat. So I think it's going to be tough for lawyers like us to fight and argue a matter where everything is given the benefit of protection of deemed protection of law, that there's a deemed fact that the information is passed. It's very difficult to disprove that.
Yeah. And this over regulation or expansion can also be seen from SEBI's attempt to widen the scope of UPSI or unpublished price sensitive information. Now, there were a few items which were earlier deemed to be UPSI, but that list has been expanded to include material events which were covered under LODR as deemed material events, or events which would become material upon applicability of certain guidelines. So, that in itself also signals over regulation or signals an attempt on SEBI's part to reduce its work.
More than that, reduce its work, it is increases the work of the listed company considerably. And it impacts employees and people working in the listed company to actually ensure that they never trade in their own stock ever. I'll tell you the reason why. Now, first, I have a fundamental issue, jurisprudential issue, as to how they have used the definition of UPSI. UPSI was supposed to never be defined in terms of the events. UPSI was supposed to be is a principle-based law to say that anything which may materially affect price of securities is a UPSI.
Correct.
Unpublished price-sensitive information. Anything which can materially 5% of stock, 5% non-stock is a price-sensitive information. So SEBI had classified four, five, just for example. Now, what happened in the past is was lot of things what SEBI thought was price-sensitive information, and there was no trading or window closure by listed companies because it was not enumerated. Because listed companies also, like pure Indian like we are, we want the line items. Is there in the line item list? Tick the box, then only they will follow. If not tick the box, they won't follow. So what has happened is SEBI in the past has found a lot of cases where compliance officers don't close the trading window only on the fact that since it's not listed as a deemed UPSI, it's not a UPSI, we did not close the trading window, and some insider, some employee would have traded in the stock. So to curb that thing, what SEBI is now seeing that how do I ensure what more and more is seen as deemed UPSI, so that companies don't have to decide. They will treat everything as UPSI. So what they have done is they have taken out the materiality definition. Material, if you see LODR regulations cover material disclosures which a listed company is supposed to make at different times. So there is a schedule in LODR regulations which provides what is seen to be material information, and what information you have to disclose upon application of materiality test. So deemed material and certain information upon application of materiality test. So they have taken out few, I think 10 to 15 items from there and included in the definition of UPSI. So now materiality is a concept is to say that if it is a material information which may you have to disclose to the exchange. So let's say declaration of dividend. They say it's a material information you need to disclose to the exchanges. So that dividend can be 0.5 rupees. It may not be material affect the price of the securities.
Correct.
But it's still a UPSI now. Now change in ratings. Now they're saying the change in ratings is a material event, revision of rating, and then they say outcome of litigation, which is a material dispute, material litigation, then you have to disclose if outcome is material. Now I ask myself, how do I ensure that if let's say I'm a listed company, I'm working with the rating agencies for a matter for my rating of my script, my bonds. So of course they will be information will be shared, and I do not know whether it will change or not. It may stable also, it may change up notch or down notch. But the entire then now, because I do not know the outcome, the entire event has to be now seen as UPSI, and that person cannot trade. So all the list of items that if you go through the 10-15 items, litigation. How do you know the outcome of the litigation? Then what happens in the entire litigation? People involved in the litigation department, all of them cannot trade.
Correct.
And not only that, compliance burden, what we'll have to do? Each of the employees for us, officer have to maintain a structural digital database. The trading window will be closed for each of these individuals. So basically, impact of it is that each of these material, which is material information, will be now seen as UPSI. How is it UPSI? What is the definition? If you see the definition of materiality under the SEBI insider trading, SEBI LODR, they define materiality on 3 counts. Anything which impacts, has a value of 2% more than turnover, 2% of more than net worth, or 5% of your total PAT. So profit after tax. So from that point of view, they say that anything in that value of any information which is higher than this value, then you have to disclose. That is understandable. It's a material listed company, shareholders should know. But is it material? Can I say that if I am I have 1,000 crore turnover, I enter into contracts, 50 contracts every day. So every a 10 crore contract becomes, because it more than 2%, every 20 crore contract becomes, every 20 crore becomes UPSI, and then I have to close the trading window. Any person who's working on that matter will be a person who cannot trade in the securities. How do we deal with a situation like that when you have juxtaposed the definition of materiality in UPSI, which has no relevance? Can you say that anything which impacts 2% of the net worth is an UPSI? Is that the definition of UPSI? 2% of my last year's turnover is UPSI. So I think what SEBI has gone wrong is that SEBI in principle has forgotten what is UPSI, what is material. It cares about its own governance, its own ease of regulation. So they think that if I make an exhaustive list in UPSI, it's for easier for me to prosecute. I don't have to then prove it's UPSI or not. So I will say that, let's say there's an agreement which is material. They will, SEBI, if the allegation is that you knew about that agreement, you were executing the agreement, and you bought the shares, therefore you've done insider trading. I will argue, no, 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 it is not a material event. It is not a material agreement. So look at the value, it's only 20 crore. How can you? Then SEBI said, no, no, go back now, see what the definition is. I have deemed this as UPSI, and anything material is a deemed UPSI. Go 2%. If it's over 2% of the turnover, it is done. And actually, it will. And the problem here is also, earlier people used to argue, see, the price of securities has not moved. Now UPSI definition, once it's deemed, the only meaning of UPSI is that information is likely to impact price of securities. Correct. It may not impact price of securities. So even if there is no movement of price of securities, it's a 20-year contract for 20 crore contract for 1,000 crore turnover company, that will still be seen as UPSI. Somebody who trades basis that information cannot. And forget about the compliance cost of the SGD trading window, etc. So I think it's a unthoughtful, in a sense, changes, but also thoughtful for their concerns. For them, it's easier to then prove somebody that they've done insider trading.
And I think once every material event becomes UPSI, the actual trading period in which a DP or an immediate relative can trade becomes very, very narrow.
Yeah, and even the 180 days, they cannot trade because of this entire thing of financial quarter, 45, 45, 45, 180 days gone, and then rest is 180. So I might as well make a rule that no insider can trade, period, finish it off. Correct. Because there's no point to all this nonsense. And also the wide nature of it, the horizon of it, connected person, everything UPSI is deemed, make a list. What is material information, make a list. Then they say the who's connected person, make a list. Deemed to be connected, make a list. I don't have to prove anything, just listing. If you tick the box here, tick the box here, tick the box here, insider trading, go home. So that's how SEBI wants to regulate. They don't want to do the hard work of finding information, drawing a link. Just give me tick the box 4, 5, I do it. That's all.
I think SEBI really confuses materiality with UPSI, because materiality is more from the perspective of providing a sense of transparency to investors, to let them know what is happening. But UPSI is more from the perspective of giving a level playing field for investors and insiders alike. So, like,
they knew about it, as in they understood the difference. But in 2025 June starting, the difference is gone. And because they thought it was difficult for them to enforce insider trading regulations without this changes. So it's not like they didn't understand that. Of course, that's how it was going on for some time. They changed it. Now it's starting, it's effective June.
Effective June 25.
So the effective June is going to be a lot of problem for listed companies and their compliances. And even for employees of listed companies, it's become very difficult for them to trade.
Correct. And apart from all these changes, a very recent circular of SEBI has come on freezing of PANs of designated persons and immediate relatives. So this system was already there for designated persons before, where stock exchanges and depository participants have been given have been given a system where they can freeze the PANs of DPs and immediate relatives during the period when the trading window is closed. So this is kind of SEBI's attempt to avoid any inadvertent non-compliance of closure of trading window norms. So this I feel is a good systematic decision by SEBI to avoid any sort of non-compliance which might be unintentional or intentional. So
No, it's good. And then might as well include for connected, deemed to be connected. Nobody trades in this script only. Point is that I understand. See, immediately blocking immediate relative, I don't think is the right process to do it. I think you can. There's a process which has been already been prescribed, that you seek approval, file NOC, take an objection from a compliance officer, and trade, which allows them to the process. Now, if you block it, it will become one more layer, and I don't see why we should, as in, create layer in terms of law itself, that I'm protecting you from law. You, by mistake, if you trade, then you'll get in trouble. I don't think that is the right way to approach. Somebody needs a medical attention, urgency. People need cash tomorrow. They'll sell the stock, get the money tomorrow. Now T+1, you get the stock tomorrow, money tomorrow. Then there's another layer. No, first you go take approval, and then you get it defreeze, and then you do it. So it's going to be a lot of problem. I mean, okay, I understand the intention, but okay,
but
let's
do
see.
you think giving the listed company the discretion to decide when this freezing of PAN should happen or when this trading window closure should happen kind of somewhere lessens the
Yeah, I think that's true. That's true, because you only decide, listed company decides, and immediate relatives also, the list will be provided by the DPs only. Because I have two son, two daughters, one wife. Wife is dependent, one son is dependent, one daughter is, but rest two, one daughter and one son are independent. They are making their own money. They are trading on them, so don't include in them in the list.
correct.
So for them, only the three people get blocked, and the rest can still trade. So that way, yeah, because you are in control of that information, you are in control of that data and the blocking itself. So I think slightly better than the other two.
So these were some of the changes that have come about in the insider trading regulations recently. Some of them are going to be effective June 2025 onwards, and their impact will be known soon. Thank you for joining us today, and we await hosting you soon in our next episode to discuss more such developments.
Thank you.